Catherine Lapel, who is a professor of law at the University of Ottawa, distinguished research chair in occupational health and safety law, who has been analyzing this issue from the point of view of what legal analysis and decision-making in accordance with the law requires as that's applied in different jurisdictions, particularly Ontario and Quebec, which she has studied intensively. So with that, I will turn it over to Catherine.
Thank you very much. I've just left the Parliamentary Commission in Quebec that is reforming the occupational health and safety and workers' compensation legislation there. I just literally finished at 12:15 my own testimony. And just for Paul and anybody else on the call who is interested in this type of issue, one of the things that is in the draft legislation is the creation of an independent scientific review panel on the one hand, and an oncological panel on the other. So somebody is reading Paul's report, I put it that way. And I look forward to presenting. I'm not going to present much on Quebec, but what I'm going to do with the about a half an hour that I've been allocated is to talk about some of the medical legal issues that can explain some of the bizarre outcomes that we see when people actually try to get compensation for themselves or for their family member who is deceased. And the presentation outline, very quickly an overview of workers' compensation systems, and I don't want to overlap with what Paul has already said, but I will just try to complete that. Provisions specific to compensation for occupational disease will be focused on. And the crux of my presentation is the question as to what the level of evidence should be to access compensation. And there's an answer to that is different depending on whether you're talking about the legal answer to the question or whether you're talking about the scientific answer to the question. And a complementary question is when it's a question of creating policy as opposed to adjudicating an individual claim, what is the level of certainty that is required before we will change a policy? So that at the end of the half hour, hopefully that's what you'll be seeing more clearly. Many of the people on this call already know the answer to these questions, but you never know. So in terms of the legal framework governing workers' compensation for occupational disease, and I'm restricting myself for the moment to Canada, there are, if I look at just BC, Ontario, and Quebec, there's exclusive jurisdiction of an administrative body. What that means is that WSIB has, at the end of the day, the answer unless the worker or his family member goes into appeal. And workers can't decide that they're going to sue John Mansville instead because they were exposed to asbestos. Normally, and depending on the provinces, the level of exclusion of compensation under the civil court or tort law is pretty broad. So basically, your only recourse in a normal situation, if you are a worker or if your family member was a worker, is to go to the WSIB if you're in Ontario, WorkSafe BC in BC, and Le SNEST in Quebec, which is our compensation board, as well as our regulator. We have, like BC, both prevention and compensation are under the same jurisdiction, the same hat, the same organization manages both. In appeal, there are specialized tribunals. In Ontario, WSIAT, the Workplace Safety and Insurance Appeal Tribunal, BC, WCAT, and in Quebec is the Tribunal Administratif du Québec, du Travail, plutôt. And they're important. And one of the things that distinguishes different provinces in the comparative work I've done is that the powers of the appeal tribunal vary depending on which jurisdiction you're in. And if you have an appeal tribunal with hands tied, you're going to have less success from a worker perspective in appeal than if the tribunal can actually hear the evidence before it and decide on the basis of the merits of the specific case. In these different jurisdictions, experience rating rules differ. What does that mean? I'll have a slide on that. I'll talk about it. But essentially, there are economic incentives built into workers' compensation systems in all our provinces. And the way they work for cancer in particular differs considerably from one jurisdiction to the next. And the effects of having experience rating that applies or doesn't apply will affect the worker's experience going through the system. Ontario is actually pretty good on this, whereas Quebec allows every employer who has ever exposed a worker to asbestos to come and contest the claim. And that leads to an awful lot of strife, if put simply. And the benefit of the doubt, as Paul said, it's in the legislation in Ontario and BC. It's not in the legislation in Quebec. So law and science, and this is really a key slide. I'm going to spend a bit more time on this one. We're talking in silos. The rules on the left hand of the screen, you have what the law requires. And if you are making a claim for compensation for, let's say, larynx cancer and you've worked with asbestos, the court cannot say, well, let's just wait for another 15 years just in case there's better data, and for now we won't decide. The court has to decide, and they have to decide on the basis of the evidence before it. And in those cases, you can't sort of abstain in the same way that you can in science, where lots of scientists will write saying, our article shows that it's possible that exposure to, I don't know, I don't want to say something heretical, but exposure to welding fumes leads to Parkinson's, but we're not certain yet. In law, you have to decide in the individual case. In law, it's the preponderance of evidence. It's sufficient in civil cases. So if you're before the courts, not before the compensation boards, it's 50% plus one, or more likely than not, that this individual's cancer was caused by the exposure that is described in the complaint. Scientific studies are not the only source of evidence in law. Circumstantial evidence, which I'll explain in a minute, can certainly make up for the fact that we don't have studies on a specific contaminant, for instance. And of course, in law, the legal decision applies to the individual and not to a population. In science, I've already covered the question of abstention, and scientists certainly are very careful in what they publish and in the tentative nature of their conclusions in many, many studies. Conclusions are based on statistically significant results, what we call alpha errors. What are the chances that we are seeing a relationship between welding fumes and Parkinson's by chance, as opposed to a causal relationship? So scientific journals will require, and apologies to all the scientists on this call, because this is a lawyer's sort of simple version of alpha and beta errors, and read the article that is at the end of this presentation if you want it to sound more scientific. But for the questions of statistically significant results, what are the chances we're seeing a relationship that doesn't really exist? You have to be 95 or 99% sure, 0.05 or 0.01. The underbelly of that is 95% certainty or 99% certainty. You don't hear about beta errors, and beta errors, and this is work, Stephanie Premji has led this. I was co-author with Karen Messing, so three very different disciplines. And Karen, when I first met her, and many people on this call will know, and she's a scientist, said, do you know about beta? And I said, no, I've never heard of beta. So beta errors are, what are the chances that you're not seeing a relationship that exists? And I teach this to my law students. If you have a class of 10 people and 7 of them have a cold, is it really by chance that it happens that these 7 people have a cold, or can we determine that being in my class causes colds? So the smaller your sample, and all the scientists know this, but the lawyers don't usually, the more likely you're going to draw alpha errors. You're going to, if the sample's tiny, you're going to assume that there's a relationship unless you do the statistical analyses to say, what are the chances that this is not caused by the fact that you're in Catherine's class? But the beta errors, when you have, say, a study of 100 people, we know that it's very likely that you're not going to have statistical significance if you don't have a lot of people in your sample. But scientists mostly don't write, well, we couldn't see an effect in this small sample, But that doesn't mean there is no effect, because the sample was tiny and therefore it's not statistically significant. But the chances that there's an effect that we're not seeing is 50%. We don't write that beta error. And what happens is judges read those scientific studies and they don't understand, when they're trying to adjudicate whether it's more likely than not, they don't understand that it's highly likely that there could be in some of these studies a relationship that people aren't seeing because the sample size is too small, for instance, or for other reasons. And the short version of all of that is that evidence required to fail to conclude on the existence of relationship is less than that required to find the relationship. So the dice are a bit loaded from a legal perspective in terms of the interpretation of scientific evidence. And again, in science, of course, the conclusions apply to populations but do not apply to individuals. So preponderance of evidence is not scientific certainty. Determination of work-relatedness requires that the preponderance of evidence, so more likely than not, supports the conclusion that exposure at work was a significant contributing factor. And Paul spoke eloquently about this, and I subscribe to what he said. Legislative presumptions are created to facilitate the recognition of a claim if the associated criteria in law or policy are proven to apply in the worker's case. So these are, I won't belabor this point because Paul already talked about it, but both in Ontario and BC, the legal language gives the benefit of the doubt to the worker. We do not have that in Quebec. In Quebec, this is just an illustration of legal language. This is our presumption provision. The diseases listed in Schedule 1 are characteristic of the work appearing opposite each of such diseases on the schedule and are directly related to the risks peculiar to that work. A worker having contracted a disease contemplated in Schedule 1 is presumed to have contracted an occupational disease if he has done work corresponding to that disease according to the schedule. So this is your equivalent of your Schedule 3 in Ontario. And in Quebec, it's very, very clear that all our legislative presumptions in relation to occupational disease can be reversed if there is evidence to the contrary that is preponderant. So the employer can overturn a presumption. What's less clear, and there's a debate in the case law, if the employer tries to come in and say, well, asbestos doesn't really cause mesothelioma, and I'm going to give you this new study that shows that, a lot of people say that the first paragraph of this legislation cannot be put into question without legislative reform. But employers should try to do it, and we've had cases where workers with mesothelioma were exposed to asbestos, lost their cases because an expert witness came in and said, well, chrysotile doesn't really cause mesothelioma. So, and that, recently, like not 50 years ago. So this is what it looks like in terms of the schedule. Ours is very simple. It doesn't say having to work for such and such a company. It's asbestos, lung cancer, or mesothelioma caused by asbestos, any work involving exposure to asbestos fiber. And for decades, there were fights as to whether the worker had to prove that his mesothelioma was caused by asbestos in order to get the presumption to apply. And the reason we have the presumption, and I'll get back to the outcome of the Supreme Court of Canada case on the question I just raised, but the basis for the legislative presumption is this, and I'm going to read it out. Particularly when it comes to occupational disease, because of the variability in the available medical knowledge regarding the true causes of some diseases, it often happens that sick workers do not succeed in their claims because they cannot demonstrate the causal link between their working conditions and the disease from which they are suffering, even though the frequency of that disease is notorious in their field of work. It is desirable that the legal and medical approach to these issues be made more flexible or even specifically adapted to the circumstances. And of course, that's the minister in 1978. Quebec had and still had asbestos mines at that time. And the widows came to testify that what would happen would be that at the time of the hearing to determine whether the miners were actually suffering from asbestos-related disease, they'd schedule the hearings. The employers would schedule the hearings so that there was a conference in Quebec at the same time, and all the U.S. specialists would come up and say, no, poo-poo. Mesothelioma is not caused by chrysotile, and we have chrysotile mines, for instance. So the minister in 78 said, this is why we're creating presumptions. This is my Supreme Court of Canada decision, And we had to go all, well, I didn't have to go all the way to the Supreme Court, but the poor widow had to go all the way to the Supreme Court against John Mansfield, because the Workers' Compensation Appeal Tribunal, the CAMP at the time, found that the worker's lung cancer was caused by his 40 years exposure in the asbestos mine without protective equipment, even though he didn't have asbestosis. And the asbestos mines went into judicial review and said this is absurd, and won. The asbestos mine won both in the Superior Court and the Court of Appeal. And this quote is from the dissenting opinion of the judge in the Court of Appeal, who says, "Is it more aberrant to imagine that in some cases the employer be called upon to pay compensation for a disease for which he should not be liable, than to conceive that a worker be deprived of compensation he was justly entitled to because of the complexity of a scientific controversy? In the context of social legislation, I don't think so. In any case, it's a policy choice and not a choice to be made by the judiciary." This is my translation. The Supreme Court of Canada said we agree with the dissenting opinion, but unfortunately there's no English version of the dissenting opinion because, of course, the judgment was in French. When no presumption applies, this is the provision. It's basically similar in most provinces. A worker having contracted a disease that's not scheduled in a course of employment is considered to have contracted an occupational disease if he satisfies the commission that his disease is characteristic of work he has done or is directly related to the risks peculiar to that work. And in practice, 99.9% of the successful claims are based on the idea that there are risks peculiar to the work, a characteristic diseases, even asbestosis. They don't say it's characteristic if it's not explicitly demonstrated outside of the presumption. Legal causation, burden of proof, preponderance of evidence. And the question is it more likely than not that workplace exposure was a significant contributing factor to the development of the worker's illness? And in civil cases, as I said, 50% plus one. And in workers' compensation in Ontario and BC, where the worker has the benefit of the doubt, the burden is actually lower than 50% plus one. This is a cluster of breast cancer cases in BC. And this is the Supreme Court of Canada discussing the importance of respecting the WCAT, the Workers' Compensation Appeal Tribunal, the autonomy of that appeal tribunal, where the appeal tribunal actually granted compensation because there was sufficient evidence when they looked at all the evidence to conclude on a balance of probabilities that these workers' breast cancer were attributable to their workplace exposures. And the reason it went all the way up to the Supreme Court of Canada was that all the scientific evidence that was before the tribunal said science cannot allow us to conclude that there is a causal relationship. The expert reports, concluding in their inability to reach scientific conclusions to support the causal association between workplace conditions and the workers' breast cancers, or to find any scientific evidence for the plausibility of a laboratory work-related etiological hypothesis regarding breast cancer, spoke not to the burden imposed upon the workers, nor even to the burden imposed upon plaintiffs in a civil tort claim, but as to a standard of scientific certainty. In my respectful view, therefore, in relying upon the inconclusive quality of the OSA report's findings as determinative of whether a causal link was established between the workers' breast cancers and their employment, the Chambers judge and the majority of the Court of Appeal erred in law. So again, we have the pattern where the Specialized Appeal Tribunal grants compensation, and then the non-specialized Superior Court of Appeal intervenes and says, no, we don't think because the scientists are against it, why would we cover this? And it's only in the Supreme Court where we reinstate the decision of the Specialized Appeal Tribunal. The Supreme Court continues in the same case. The presence or absence of opinion evidence from an expert positing or refuting a causal link is not, therefore, determinative of causation. It is open to a trier of fact to consider, as the tribunal considered, other evidence in determining whether it supported an inference that the workers' breast cancers were caused by their employment. Causation can be inferred even in the face of inconclusive or contrary expert evidence from other evidence, including merely circumstantial evidence. And finally, for those who are concerned about this, This does not mean that evidence of relevant historical exposures followed by a statistically significant cluster of cases will on its own always suffice to support a finding that a worker's breast cancer was caused by an occupational disease. It does mean, however, that it may suffice. Whether or not it does so depends on how the trier of fact, in the exercise of his or her own judgment, chooses to weigh the evidence. And I reiterate, subject to the applicable standard of review, that task of weighing evidence rests with the trier of fact, in this case with the tribunal. So the trier of fact is the WCAT. In Ontario, it's WCAT, and in Quebec, it is the TAT. So now I'm going to segue into just a couple of slides to look at the creation of policy as opposed to adjudication in individual cases. And I did a study 10 years ago, and OCA was actually one of the sponsors of that study on asbestos and compensation in 5 jurisdictions across Canada. And we found, first of all, when you look at the legislation and the regulations, lung cancer and policy is presumed to be related to asbestos exposure. And you have up here BC, Newfoundland, and Ontario. BC requires proof of asbestosis or fibrosis. Newfoundland, 5 years of exposure and 10 years of latency. Ontario, 10 years of exposure and 10 years of latency. And in Quebec, you saw the presumption, there's nothing explicit. And the appeal tribunal, because there's nothing explicit, is much more flexible in terms of issues of latency, be it for mesothelioma or be it for lung cancer. In practice, what we found in our study that claims by non-smokers will be accepted in all those jurisdictions, despite absence of asbestosis. Sometimes you have to go into appeal, but they eventually accept them. If asbestosis and smokers, claims will be accepted when the criteria are met or almost met. And if there's no asbestosis in smokers, claims have been accepted in Ontario and Quebec if there's evidence of very significant and intense exposure. So that what you've got, I mean, this is all science, and lawyers naively think, well, science knows what it's doing. But if it was that scientific, why would it be 5 years, 10 years, or no years, depending on which province you live in? So that there is politics underpinning all these policies, and we have to remember that, because otherwise we have the illusion, well, science says that you need 5 years exposure or 10 years exposure, and you only have 9.5. I've seen this in judgments, and therefore it must be that you got it at home. So there are equity-related concerns. Policy and scheduling of diseases seem to be predicated on scientific certainty with regard to exposure and latency requirements and with regard to diagnostic requirements. Yet workers should be compensated if it's more likely than not that asbestos caused their disease. And free access to several specialists who can provide accurate diagnoses and exposure analyses is not available in all provinces. So just for example, and the scientists and probably everybody on this call knows that when you have an epidemiological study, you're looking at averages. And we know that latency periods for mesothelioma on average is between 20 and 40 years. I have seen judgments in Quebec, and I'm sure they exist elsewhere, that say, well, you were only exposed to asbestos 10 years ago, so we are denying your claim. Okay, I'm getting messages from my computer here that I'm going to ignore. Okay, so getting back to what I'm saying, if you're the person who is more susceptible than the average person, and it only takes you 10 years before, after your exposure to get mesothelioma, you can be compensated if the judges understand that these aren't checklists, but policies based on averages, and that it's the individual who has to be evaluated and not the population. And the same thing, free access to several specialists, in Newfoundland in particular. If you can't get a diagnosis of asbestosis because there's no specialist who can diagnose it, you even if you have a really good compensation system, you're not necessarily going to get compensated. And I take Newfoundland as an example because that came out of our study, but it can happen anywhere. If the criteria aren't met, compensation is available on the basis of individual merit of each case. Decision makers in those provinces with stringent criteria and policy are often reticent to accept claims that don't meet policy requirements. And this was our finding when we were looking. Paul talked about his burden of cancer report. I haven't published what we did, but we looked at the WISIAT decisions in relation to those 10 carcinogens, and the proportion of cases accepted in appeal by WISIAT is way, way lower than what I see in other provinces, in particular in Quebec. And I believe it's way, way lower because WISIAT feels it is bound by board policy. There is something in the act that suggests that it is. It's not that they made this up. And so their hands are tied, and they're trying to adjudicate with their hands behind their backs. And that means that in practice, if the WSIB doesn't accept, it's unlikely that WISIAT will hear you. Whereas in Quebec, the Tribunal Administratif du Travail has done an excellent job, and our lists haven't been updated since 85, but the case-by-case case law isn't that bad. Preponderant evidence of exposure and medical evidence regarding diagnosis and disability is required for a claim to be accepted, but that is much less clear when WISIAT feels it's bound by board policy. A couple of words on experience rating, and I'm almost done here. I'm not quite aware of the time because I lost my clock. But here, experience rating and incentives. Ontario, the best of my understanding, the WSIB looks at long latency occupational diseases and say they are not experience rated. Employers can contest claim, but they have no economic incentive to do so. In Quebec, we have dozens and dozens of cases where the worker or the widow is by herself, and we've got 10 employers with 10 lawyers and 10 doctors in construction, for instance, all trying to claim that it wasn't in my place that they were exposed, or that chrysotile asbestos does not cause mesothelioma. And sometimes they win because the widow has no evidence beyond what's in the file. And France does something different, which is to only experience rate the current employer. And for long latency diseases, I find this bizarre. And this morning I testified that I was hoping that Quebec would stop experience rating cancer claims. I don't know if that's going to happen, but that was my position. So this picture here speaks for itself, and everybody on this call knows about this, but misinformation is sometimes introduced by expert witnesses and lawyers, and structural imbalances fail to guarantee that misinformation will be corrected. So limited presumption in regulatory frameworks. As I say, Quebec hasn't changed since 85, but the appeal tribunal has been doing a relatively good job, and they're working on reforming the table in 2020. And my fear is that they're going to, even with the best of intentions, start introducing scientific certainty as a value that we have to avoid for reasons that I've explained. You've got more diseases in Ontario that are listed. You have irrefutable presumptions. In Quebec, there's an important report that came out in February 2020 that said mesothelioma should be the subject of an irrefutable presumption. That suggestion was not respected or complied with by the minister when he tabled his legislation. It's not in there. And the appeal tribunal in Ontario seems to be very reticent to intervene. So challenges moving forward: how can we ensure equitable access to exposure measures and occupational physicians? And training, and I think Paul's point is great, and it came up in the Parliamentary Commission yesterday. We need to train occupational physicians as well, and all physicians about occupational hazards. How can we intelligently address incentives contest claims in Canadian jurisdictions? And how can we improve the list of illnesses presumed to be work-related in regulatory frameworks and policies? And how can policy and practice address synergies in exposure to carcinogens? Take-home messages are here. Purpose of workers' compensation law is not to find the accurate scientific answer to a question raised by a worker's claim. Structural imbalance must be addressed. Policies should be designed to compensate for the structural imbalance by preventing the misuse of scientific data. Policymakers, decision makers, advocates, and researchers must be made aware of the perils arising from the misinterpretation and misuse of scientific evidence. And finally, access to support in tracing exposures and gathering the medical evidence should be provided to all workers. We don't have an Office of the Worker Advisor in Quebec. It's another issue that was raised in the Parliamentary Commission. So I think I'm done. You've got about 10 slides of references that I'm not going to go through here, but I'm happy to give anybody who wants it a copy of this presentation. Thank you.
Thanks very much, Professor. That was a great presentation.